Hello and welcome to the training on the development and implementation of the Detention Risk Screen for Juvenile Court. This training will familiarize you with the Detention Risk Screen process as enacted in Public Act 16-147, an act concerning the recommendation of the Juvenile Justice Policy and Oversight Committee. The detention risk screening process is effective January 1, 2017, in conjunction with the new grounds for detention, which amends Connecticut General Statute, Section 46B 133, C and E, to reduce the grounds from 6 to 3. 1. Probable cause the child will pose a risk to public safety. 2. Need to hold the child to ensure the child's appearance before the court. Or 3. Need to hold the child for another jurisdiction. There are 4 goals for today's training. First, we will review what the risk screen is in order to provide a foundational understanding of what the instrument is designed to accomplish. Second, we will outline how the risk screen was developed and finalized. Third, we will review the components of the risk screen so you have an understanding of the risk screening process. Lastly, we will walk through how the risk screen will be utilized in the juvenile case process, including the roles of juvenile detention, juvenile probation, and the court. What is a risk screen? A risk screen is a brief instrument designed to measure a specific type of risk, such as risk to public safety or risk to recidivate. Such tools are used to inform the judicial process at specific decision points. These instruments are scientifically based, provide consistency, uniformity, and objectivity, and support professional judgment. The Judicial Branch Risk to Public Safety Screen has been designed to assist the court in the decision about which child may be detained on the new, more narrow grounds for detention. The Detention Risk Screen is designed to specifically measure risk to public safety, the risk of a respondent committing a public safety offense prior to case disposition. The risk screen provides the statistical likelihood or probability of a threat to public safety as the child's case moves through to disposition. This particular risk screen does not measure risk of any arrest or general recidivism. Rather, it measures the risk of rearrest for a subset of offenses considered threats to public safety. The Detention Risk Screen was developed through an interagency committee process. The Juvenile Justice Planning and Oversight Committee Incarceration Workgroup was initially charged with the development of the risk screen. A subcommittee of the Incarceration Workgroup, with guidance from Professor Steve Cox of Central Connecticut State University, developed the validated instrument. Dr. Cox and the data staff of the Judicial Branch Court Support Services Division began with the analysis of over 6,000 juvenile arrests that occurred in 2015. The research identified information contained in the CMIS case management system correlated to future public safety arrest. More than 6,000 distinct court referrals for a child's initial arrest in 2015 were tracked. Some of the children had prior court histories and some had future arrest. Based on the statistical analysis, the researchers determined which case elements were related to an arrest for future public safety offense. The researchers generated a list of all rearrest offenses that juveniles committed after their initial 2015 arrest. Based on this list, the subcommittee members identified a subset of public safety offenses to be used in the risk screen. Of 6,183 juvenile arrests in 2015, only 2.2% were rearrested for public safety offenses between the original arrest and case disposition. Based on the research literature and questions from the workgroup members, the researchers assessed the relationship of over 40 data points potentially related to public safety. Only those data points statistically related were included in the risk screen.
The next 2 slides detail the 10 data points that are demonstrated to have a statistically significant correlation to public safety rearrest. 1. Are there any prior judicially handled dockets? 2. Are there any prior delinquency commitment dispositions? 3. Are there any prior felony adjudications? 4. Are there 2 or more prior dispositions to supervision? This includes all judicial and non-judicial supervision types. 5. Is the child currently on probation? 6. Are there 2 or more prior school-based arrests? 7. Are there any prior charges of violation of court orders? 8. Are there any prior charges of violation of probation? 9. Does the instant offense include 2 or more charges? And 10. Does the instant offense include felony charges? All of these data points are available in the Case Management Information System to both juvenile detention and juvenile probation staff. The screen will score each item as yes or no. A yes response will score 1 point, while a no response will score 0. There are both historical items and items specific to the arrest initiating the detention risk screen. The items specific to the arrest are referred to as the instant offense on the risk screen, while the historical items are referred to as prior.
Once each of the risk to public safety items is scored, a total risk to public safety is tabulated. The total score is utilized to assign a risk to public safety level. If a child scores between 0 and 2 points, he or she is assigned level 1, meaning he or she has a 1% likelihood of committing a future public safety offense prior to case disposition. If a child scores 3 to 5 points, he or she is assigned level 2, meaning that he or she has a 4% likelihood of committing a future public safety offense prior to case disposition. If a child scores 6 to 10 points, he or she is assigned a level 3, meaning he or she has an 11% likelihood of committing a future public safety offense prior to case disposition. Detention staff will complete the risk to public safety screen for any child presented at the detention center. The classification and programming officer will complete the screen using the information available in CMIS. If the classification programming officer is unavailable, the shift supervisor or lead juvenile detention officer will complete the screen to determine the child's level of risk to public safety. The completed screen will be reviewed by the detention deputy superintendent for accuracy and the possible need to override the risk level. The deputy superintendent will complete the screening process by recommending the child for release or detention. Pursuant to Connecticut General Statutes 46B-133F, as amended by Public Act 16-147, Section 3, unless there is an order not to release noted on the child's taken to custody order, arrest warrant, or order to detain, the child may be released to the custody of the child's parents, guardian, or other suitable persons or agencies in accordance with policies adopted by the Court Support Services Division of the Judicial Branch. In accordance with CSSD policy, when a child scores as a level 1 on the risk to public safety screen and there is no order prohibiting release, detention staff may release the child to the child's parent, guardian, or other suitable person or agencies. The release of any child must be authorized by the detention superintendent. If a child is eligible for release and the child's parent, guardian, or other suitable person or agency refuses to take the custody of the child or is unavailable, the child will be held in detention until the initial court hearing or until the child's parent, guardian, or other suitable person or agency can pick up the child. If a child is released prior to court, the child and the child's parents, guardian, and other suitable persons or agency representatives will be given a promise to appear for court on a specific date and time. In accordance with CSSD Juvenile Services Policy 7.19, juvenile probation will seek a taken to custody order on any child who is absconded and has been missing for over 24 hours. A TIC may also be sought in cases in which juvenile probation believes the child presents a public safety risk or has been non-responsive to the court process and is a risk to failure to appear. The judge will need to determine if the criteria for detention has been met. If the state's attorney seeks detention for a child presented at court on a promise to appear for another court hearing, the prosecutor should file a written motion seeking an order of detention or the JDJM 9A form, application for order of detention. The court will need to pass the case in order to have the juvenile probation complete the risk to public safety screen. Once completed, juvenile probation will submit the juvenile detention eligibility screen with a recommendation for release or detain. The judge will need to determine if the criteria for detention has been met. Pursuant to Connecticut General Statute 46B-133, as amended by Public Act 16-147, Section 2B, when a child is presented before the court and it appears from the available facts there is probable cause to believe the child has violated a valid court order, the court, after administration of the detention risk screen, may order the child to participate in non-residential programs for intensive wraparound services, community-based residential services for short-term respite, or other services and interventions the court deems appropriate. While the detention risk screen itself cannot be admitted into the court record, per Connecticut General Statute 46B-124L, as amended by Public Act 16-147, Section 4, the risk to public safety level and recommendation will be submitted to the court as part of the juvenile detention eligibility screen form. The juvenile detention eligibility screen, risk to public safety, will be completed by juvenile detention staff or probation officers who are responsible for the screening process. The screening will indicate the child's risk to public safety level, Level 1, Level 2, or Level 3, and will make a recommendation to the court to release or detain the child. Risk to failure to appear will be completed in court at the time of the child's hearing. All parties will discuss the child's risk for failure to appear as demonstrated by previous failures to respond to the court process. Once all arguments are heard, the court will select one of the following: previous failure to appear in court, previous failure to respond to the court process, not applicable. For the purposes of definition, court-ordered appointments are appointments such as clinical evaluations, a pretrial hearing, or other appointments that the child is ordered by the court to attend. There needs to be evidence that the child's failure to respond to the court process was willful and not the result of being sick or impeded to attend by the parent. While meeting with one's probation officer may be a condition of probation, for example, missing a meeting with one's probation officer is not considered for this purpose to be a failure to respond to the court process. Lastly, the judge will order one of the following: motion to detain denied, the child released, or the child detained. If the child is to be detained, the judge must find a grounds for detention. 1. That the child poses a risk to public safety. 2. To hold the child to ensure the child's appearance before the court. Or 3. To hold the child for another jurisdiction. Pursuant to Connecticut General Statute 46B-133, as amended by Public Act 16-147, Section 1E, if a grounds for detention is found, the court may, in its discretion, consider as an alternative to detention a suspended detention order with graduated sanctions. If the grounds for detention is not found, the child may not be placed on a suspended order of detention. This is the new JDJM 214 form, Juvenile Detention Eligibility Screen, which will be available for use on January 1st, 2017, the effective date for the new grounds for detention, and the requirements for determining eligibility for detention based on a risk to public safety or a risk for failure to appear prior to case disposition. Thank you for your time and attention in completing the Juvenile Detention Risk Screening Training. If you have any follow-up questions, please notify your supervisor or an administrator who will facilitate getting a response to you.